Your NDA sucks because it's not tailored to your situation. Part 2, I'm Steve Hansen. I've been a practicing patent attorney for over 25 years. Not only do I write patents, but I tear apart other people's patents in litigation. If you like this content, please like, follow, and share. So as I said in the last video, a key with an NDA is to make sure it's appropriately tailored to your situation. I cannot tell you the number of times I've had people come to me and say, here's the NDA that we have. And I said, this has nothing to do with what your relationship is. All you did was take an NDA you used in some completely different context and have them sign it here. And it's going to provide you with no benefit whatsoever. So as a client, I'm not trying to teach you how to write NDAs. What I'm trying to teach you is how to think through what the important information you need to give to the attorney who is writing it is. Okay. And as a client, I think there's 2 key thought experiments that you need to do, and the results of which you need to communicate to your attorney. The first is, what information do you plan on disclosing specifically, and to whom, and what do you expect them to do with it? Like, what do they want, and why do you think, or why do they think they need it, and why do you want to let them see it? Because then you can start to put some parameters in the agreement about what is permissible. That will also help you if there's a dispute later about whether what they did breaches or doesn't breach the NDA. You can put in some recitals that describe what you do expect them to be doing with the information. The flip side of that, of course, is also important. What is it you are worried about them doing that you don't want them to do? You want to have those prohibitions explicit in the NDA. Typically, there are at least 3. The first is you usually don't want them to take your information and file their own patent application on it. Now, hopefully, before you've disclosed anything to them, even under an NDA, you have your own patent application on file. But no matter what, you don't want them to use your information to file a patent application. The second thing is that you don't want them to use your information to commercialize their own product or do something to enhance their own business unless they enter into some sort of arrangement with you. A lot of these NDAs are for the purposes of scoping out a potential relationship, but you don't want them to take your information and use it for their own purposes. You want them to use it for your collective purposes and the reason that you are working together in the first place. And the third one is you don't want them to disclose it to third parties, because if the information you are providing them is trade secret, that trade secret status will be lost once they disclose it to third parties. So I would encourage you as clients to really think through who's going to get the information, what they're going to do with it, why they're going to do with it, and talk to your attorney about this so the attorney can help you draft an appropriate NDA. I'll talk more about some nuts and bolts in the next video, but I hope it helps to keep you out of trouble, and I hope to see you here soon.